The Leadership and Integrity Bill outlines the various constitutional values, principles and requirements which every state officer has to meet. What many would like to know ahead of the coming general election is whether candidates facing criminal charges can be allowed to vie for any position.
Karibu sana, karibuni sana.
The spotlight has particularly been shining on presidential aspirants Uhuru Kenyatta and William Ruto, who are now facing charges of crimes against humanity at the International Criminal Court. The proposed law gives authority to the Ethics and Anti-Corruption Commission to vet a particular state officer or a candidate for election or appointment to a state office in accordance with the provisions of Chapter 6 of the Constitution. Where the Commission finds one not compliant, that state officer or candidate shall not be eligible for election or appointment to a state office or public office, as it will not then issue a certificate of compliance. Article 73, Section 7 of the bill further states that in addition to the information received from the Ethics and Anti-Corruption Commission and the bodies such as the National Intelligence Service, the Kenya Revenue Authority, among others, the recruiting or appointing body or person may consider information about the past record of a candidate for election or appointment to a state office. The proposed law clarifies that past record includes but is not limited to past trials, convictions, acquittals, and any current charges. Some lawyers, however, argue that the bill, and particularly Article 73, is still vague because it doesn't publish the guidelines on the vetting criteria and issuance of certificate of compliance. The proposed law instead indicates that the Ethics and Anti-Corruption Commission may, as necessary, issue those guidelines. Further, Section 10 of Article 73 indicates that a person who is dissatisfied with the decision of the Commission or any other public body acting under this section may appeal to the High Court. Human rights crusaders expected the bill to expressly bar candidates who are facing criminal charges, but it seems the drafters left it to the interpretation of Article 99 of the Constitution, which only bars candidates who at the time of the election are subject to a sentence of imprisonment of at least 6 months or contravened other provisions of Chapter 6 of the Constitution, which provides guidelines on leadership and integrity. Among other highlights is that the proposed law provides that a person who has been debarred by their professional body for breach of code of conduct and ethics may also be barred from election or appointment to a state office until the debarment is lifted. Clause 14 of the bill provides for financial integrity and prohibits state officers from using their position to improperly enrich themselves or others. Sylvia Chebet, Citizen Weekend.